Good morning. I'm very grateful to the organizers for inviting me. I'm Sandra Recchione. I work as a judge for preliminary investigation in Torino district in Italy, and in past time I worked as a public prosecutor in Palermo. I had a long experience as a trainer for judge and public prosecutor, and my presentation regards the victim's crime and especially the vulnerable victims in EU system. I want to start my exposition by describing the lack of Italian legislation and representing the hope that the enforcement of a new directive can create for the condition for an effective improvement of guarantee in the process for all victims, but especially for vulnerable victims. The European legislation, and especially the new directive, obliges the states to enhance special measures to avoid the secondary victimization depending on process. Many of the indications of this European Act are already present in the framework of international legislation. We can consider the indication of Directive on Preventing and Combating Trafficking in Human Beings and Protecting its Victims. Directive establishing minimum standards on the rights, support and protection of victims of the crime. Convention of Lanzarote on the protection of children against sexual exploitation and sexual abuse. Convention of Istanbul on preventing and combating violence against women and domestic violence in general. So, what is the Italian situation? Currently, in the Italian system, the rational and organized measures to contrast the secondary victimization do not exist. The lack of protection concerns a lot of areas. The first, the absence of shared and legislative notions of the vulnerable victim, which do not refer to specific crimes or the condition of the victim, for instance, disability or underage. Second, the absence of the coordinated system to obtain the contraction of the victim's hearing. Third, the relevant role of psychological evidence and the difficulty in individuating a shared method of analysis among the scientists. The absence of an extrajudicial network of assistant and social operator with the aim to protect the victim during and after the process. Finally, the lack of participation rights of the victim during the investigation with the subsequent risk of a good implementation of evidence and the subsequent negative effect on the final result of the process. Now, the ratification of the Convention of Lanzarote does not improve this system. Protection is reserved only for minors, and the presence of psychological experts was announced in no rational manner. The new challenge is the enforcement of the new directive. With this act, the precise guidelines have been drawn up for create a rational system to protect all vulnerable victims. The most important measure to protect the victim in Italy is the anticipation of testimony during the investigation stage, with the incidente probatorio. This institute provides the possibility to form the evidence during the preliminary investigation. investigation. The public prosecutor or the lawyer of the accused can ask the judge for preliminary investigation for the anticipation of evidence. So, the vulnerable victims can be heard during the investigations immediately. The act of investigation, if the incidente probatorio is admitted, must be available to the accused and his lawyer, and also to the lawyer of the victim. The secret comes out in this way, and it is a relevant cost of this procedure. The hearing of incidente probatorio must be audio taped, but it is common to utilize the video recording. The victim is asked by the judge and, in some particular cases, by the psychologist. The act of incidente probatorio can be used as evidence. In theory, it is a good system to protect the victims. What are the problems? A lot. The first is the absence of criteria to identify the vulnerable victims. The first issue is that the anticipation of the testimony is not possible for all vulnerable victims, but only for some special victims identified by a specific crime, object of the proceeding. So, for instance, the special procedure is not provided in the cases of the exploitation of prostitution when the victim is an adult. The vulnerability does not depend on the type of crime, but by the personality of the victim and by its relationship with the author or with the fact. The new directive provided a special assessment to decide whether and how the victim is vulnerable. In 2005, the EU Court drew the lines to interpret the Italian rule in consistent way to indications of the framework decision, with an important sentence, case Pupino. So, the Italian Supreme Court had considered admissible the anticipation of testimony in one case that is not provided by law. So, a child's testimony of the mother testified in a protected way in spite of murder is not indicated by law in the special cases that allow the anticipation of evidence during the investigation. The other problem is the absence of guarantees of an effective collection of victim statement. The cases that permit the anticipation of testimony during the investigation are more numerous than the cases in which the Criminal Procedure Code provides the prohibition of a new testimony during the trial. In fact, the result is that the special measure of anticipation of evidence produces a paradoxical effect, increasing the number of statements instead of reducing them. Another big problem in Italy is the difficulty in managing the scientific proof when the vulnerable victim is underage. Normally, in the processes regarding minors, the public prosecutor decides to utilize the scientific competence of psychologists to find out if the young witness is capable of testifying. In this area, the main problem is that the psychologists do not share common ideas about the best methods to comprehend the mind condition of the minor. Many scientists believe that minors are too easily influenced by contact with adults, especially when these have a great interest in the conviction. These scientists believe that the behavior of adults can breach the credibility of the minor's testimony. Some of these have a very rational approach regarding the structure of the testimony and underline every incongruity or logical fracture during the development of narration. Other psychologists prefer a clinical approach and analyze the emotion and the body communication. These different approaches produce an important point of crisis in the process for sexual abuse. Another problem depends on the respect for the right to a fair trial. The scientific evidence is formed during the investigation, and so the accused does not see the secret document of the investigation stage and cannot intervene during the analysis. Normally, after the secret analysis made during the investigation stage, the scientific proof has to be repeated, and so another assessment will be renewed. The Court of Cassation recently decided that the denial of the incidente probatorio regarding the psychological state breaches the right to fair trial. However, the frequent repetition of psychological assessment produces a relevant trauma in the young witness, directly depending on the development of the proceeding. Recently, the law that ratified the Convention of Lanzarote provides the obligatory presence of a psychologist during the statement of minors, carried out by the police or the public prosecutor or the lawyer of the accuser during the investigation stage. But this reform is full of problems. The first is the difficulty of trying the expert during the first stage of investigation. The second is the unnecessary presence of an expert when the minor is almost an adult, and the presence of expert overcomplicates the process. The third, delegating the hearing to the expert can transform a judicial act into psychological assessment, and the main objective of the investigation can be forgotten. However, it is certain that the expert cannot hear the witness without the presence of the authorities entitled to form the evidence, the lawyer of the accused, the public prosecutor, or police. Another big problem is the absence of assistance during and after the process for all victims. The Italian system is characterized by a lack of extrajudicial assistance for victims during and after the process. In Italy, this assistance mainly depends on the goodwill of social operators and assistants, who do not have a structural link with the victims established by law. The organization that helps the victims of human trafficking, the victims of the exploitation of prostitution, or the female victims of domestic violence is not linked to the network and, above all, does not have a stable connection with the judicial authorities. This situation involves a perceptible disorientation, and the victims, especially if they are vulnerable, do not have any clear point of reference when they decide to report the crime and start the tormented path of unveiling of their abuse. Nevertheless, in some Italian judicial districts we have the best practices. The social organization have drawn up some protocols with the public prosecutor offices and the sanitary centers, Milan for instance, with the aim to enhance a coordinated and efficient solution to the urgent problems that occur during the first contact between the victims and the penal jurisdiction. In the case of sexual abuse or in the case concerning the exploitation of prostitution, when the victim is underage, the Italian Criminal Code states that during the judicial hearing and generally during the process, the minor can have the assistance of his parent or other people in whom he has trust and confidence. The law that ratified the Convention of Lanzarote intervenes in the Article 609 and states that child assistance can be assured also by the presence of person, the company, foundation or non-governmental organization. Is a problematic provision because this provision presents a risk of transforming assistance into a formality. In fact, the victim does not have any contact with the social operator and that can help the minor during the testimony. Moreover, it is necessary to underline that the consent of minor is a strange concept, and because the minor does not comprehend the role and the function of these people and the role of no governmental organization. Besides, the presence of this assistance overcrowds the setting, which normally is just composed of the public prosecutor, the psychologist, and also by the assistance of the public prosecutor. This protection is limited to the processes concerning sex-related crimes, when the victim is underage and when it is evident that the psychological assistance of victim is a problem that involves every vulnerable victims. Also, it is necessary to underline that normally the trauma is caused by the process itself, and at the end of this, the necessity of protection is increased. Unfortunately, after the process, the victim is alone. The penal system does not provide any kind of economical or logistical assistance. The loneliness of the victim after the process is a problem, so much so that the fear of this condition influences the immersion of crime. The victims prefer not to report their abuse rather than to have to go through the stressful ordeal of a process without any protection. The new directive states in the Article 8 the rights to protection also after the process for a sufficient time. Also, the Convention of Lanzarote states the same indication. Another big problem is in Italy the lack of rights regarding the participation of the victim in the investigation phase. The Italian system does not provide the rights for the victims to actively participate in the development of the investigation and to contribute to finding and building the evidence. The role of the victim during the first very important phase of the penal process is limited. The victim can report the crime, ask the public prosecutor if it is possible to be heard in incidente probatorio, present an opposition when the public prosecutor asks for the dismissal of the case before the judge of preliminary investigation. The victim cannot present the appeal against the decision of the public prosecutor regarding the rejection of incidente probatorio. The Luxembourg court decided that the Italian system is compatible with the European law, the framework decision in this time, because the Italian jurisdiction focused the power regarding the investigations on the public prosecutor. So, the rights of the victims are integrally in the hands of the public prosecutor, and his decision regarding the way to conduct the investigation is not contestable. This interpretation, which concerns the limitation of the victim's rights during the investigation, is in contrast with the consideration of the victim as a part also during the investigation stage, which we can find in the decision of European Court of Human Rights. In the judgment Sottani versus Italy, the Strasbourg Court makes evident that the requests of the victims during the investigation are very important. On the one hand, for the best results concerning the gathering of the evidence, the victim knows the fundamental elements of the facts that are the focus of the process, and on the other hand, for the best exercise of the victim's civil rights in the penal process. Another lack. The Italian system provides the notification of the end of the investigation to the accused and their lawyers. This act must not be communicated to the victims and their lawyers. Thus, the victim cannot participate in the debate concerning the evidence which characterizes this important phase of the proceeding, a sort of pre-trial confrontation between the public prosecutor and the lawyer without the judge. That is very important to understand what is the real evil of the proof. The victim can formally become part of the process during the first hearing, udienza preliminare, of the trial. But when the investigation has been concluded, it is probable that the fundamental evidence has already been dispersed. Much of the relevant evidence is now only by the victim, whose contribution was carefully removed by the investigations. Another problem is the absence of obligation of videotaping the hearings of the victim during the investigations. The videotaping is requested by the Convention of Lanzarote, the directive regarding the trafficking of human beings, the directive regarding the minimum rights of victims in the penal process. But The Italian law does not provide this obligation. Actually, the diffusion of videotaping should promote the real contraction of the hearings of vulnerable victims. The extreme usability of this kind of documentation has a strong potential to block the necessity of hearing again and again the victim after the first statement before the public prosecutor during the investigation stage. In fact, if the defendant and his lawyer throughout the videotaping vision can see and hear the victim during his first statement, it is possible that this evidence will be considered sufficient to permit all criticism from the accused. The accused can analyze the full contents of the pre-trial hearing, but can also observe the way in which it has been characterized, the questions, the setting, the body expression, the feelings of the victims that are visible during the hearing. The problem is the compatibility of the utilization as evidence of videotapings with the rights of the defendant to confront directly the accused, which is the most important expression of the right to fair trial provided by Article 6 of Convention of Human Rights and by Article 111 of the Italian Constitution. The Italian system provides the absolute fracture between the phase of a preliminary investigation and the phase of the trial. The statements made during the pre-trial are strictly not usable during the trial. The indications of the European Court of Human Rights are not so severe. The deferred criticism is considered sufficient to grant the fair trial provided by Article 6 of the Convention. The decision SM versus Witten is one of the last frontiers to the right to a fair trial drawn up by the European Court. The ratio decidendi of this extreme extension of the rights provided by Article 6 of the Convention is the great evaluation of the agreement of the lawyer that represents the defendant during the investigation at the pre-trial hearing without the presence of the accused. It could be possible to imagine some possibility of avoiding the repetition of hearings of vulnerable victims based on the consent of the accused, who has the possibility of seeing the videotaping formed during the investigation stage. It could be a compatible solution with the Italian Constitution, which already provides the voluntary limitation of the trial access, depending on the choice of the accused. The accused can decide to be judged with the first process based on the acts of investigation. On the other hand, the obligation of videotaping the pre-trial hearing of vulnerable victims would enhance the choice of the fast process and also avoid the number of statements made by victims. So, thank you for your attention. Beh, vediamo come è venuto. Quanti minuti è?